Hello. Hi, welcome everyone. For those who are joining us via Zoom, we'll start in 2 minutes. Thank you.
All right, we're going to get started here. I'd like to welcome everybody. My name is Joe Volpe. I'm a U.S. Magistrate Judge here in the Eastern District of Arkansas, and was tasked with organizing this Power Act CLE. And I am very glad to be here, glad to see all of you all here, and appreciate you taking your time to come here on the Friday afternoon. It's only about 118 degrees outside, so I appreciate all of you being here. I want to start off by thanking our esteemed panelists that we have here today, our speakers. I'm going to introduce Ms. Stone here in a moment, but our panel also includes Justice Wood from the Arkansas Supreme Court, Judge Johnson from the Pulaski County Circuit Court, Judge Watley, I believe, is on her way over here, also from the Pulaski County or the 6th Judicial Circuit Court, Pulaski and Perry counties. And just by way of introduction, and also I guess I need to introduce our esteemed moderator on the panel, who Judge Miller agreed to do this many months ago, like our panelists. And of course, I'm sure it sounded good at the time. And when I texted him earlier this week, he was in Colorado on his way to Oregon for a meeting. And so I'm sure you would have preferred to be back in Helena after a long week of travel, but we appreciate it. Judge Miller sits on an important committee for our judicial conference, which takes him a lot of places and keeps him very busy in addition to all these other things. So I appreciate your time and your willingness to be our moderator for our panel today. The Power Act is a government acronym. It's the Pro Bono Work to Empower and Represent Act of 2018, the Power Act. And I know you all know a little bit about it, but the actual statutory language says not later than 1 year after the date of enactment of this act and annually thereafter for a period of 4 years, the chief judge or his designee for each judicial district shall lead not less than one public event in partnership with a state, local, tribe, or territorial domestic violence service provider or coalition, and a state or local volunteer lawyer project promoting pro bono legal services as a critical way in which to empower survivors of domestic violence, dating violence, sexual assault, and stalking, and engage citizens in assisting those survivors. A little bit of inside baseball. The Congress came up with this plan, and the judiciary has people that work on the Hill, and realized they were working on this and said, hey, you haven't really consulted with us, and we don't think that the judiciary is necessarily the federal judiciary that really doesn't handle these types of cases is the right task or task person for this. And so I wish Jonathan Ross was here. He's not here, our acting U.S. attorney. He was supposed to be here, but the judiciary said, who better than the U.S. attorney should be designated to be the person to do this. And so the judiciary pushed pretty hard for Congress to change it from the judiciary or the chief judge of the district to the U.S. attorney of each district. And then without any consultation, and really was surprise, they passed the law, and then it was signed by the president. And so then Judge Miller, you were the chief judge at the time, we were all kind of scratching our heads going, there's really kind of some separation of power issues and things. Why is Congress asking us to do this? What do we know about domestic violence? And so it was not well received, to be quite honest. But I will tell you that, and I volunteered back then in 2018 with Judge Miller. I said I'd be willing to take a stab at trying to organize something, and really didn't know what we were going to do. But it's been a real blessing. Okay. And the reason why it's been a blessing is, one, hopefully through this effort, maybe one survivor has been assisted with some sort of effort from some lawyer or pro bono support that has enabled them to be empowered. So even if we've only helped one person, I think it's worth it. But also we have made excellent partners and friends in this process. And it's really led to the federal judiciary here in the Eastern District of Arkansas and the Western District, because we pass it back and forth, forging what I would call excellent relations with our state judiciary colleagues, our nonprofit partners, such as we have here today, the Arkansas Free Legal Answers Program, the Center for Arkansas Legal Services, and Legal Aid of Arkansas. And we've established strong relationships and partnerships with those organizations. And also, which me, by my dumb luck, stumbled into the Arkansas Access to Justice, and Jordan Rogers Bates, was at the time in the position that Edith Chavez was in, and Judge Amy Johnson was the director. And we went to them and said, hey, we don't really know what we're doing here, and here's this act and all that stuff. And they just took the ball and ran with it, and have been running with it since 2018. And Judge Johnson took the bench, and Jordan became the director, and now Edith is playing in Jordan's role. And so it's just been in my opinion, a great partnership. And I know in the Eastern District of Arkansas are extremely grateful for all that you all have done to put this together, because this really is organized by them. The infrastructure is almost all by them. And then, and there's our U.S. attorney. And I also, talking about infrastructure, would be remiss if I didn't thank our clerk of court, Tammy Downs, who has worked tirelessly to put this all together, and her team of IT professionals. And we have our very own, what we call him, the commish. He's our fantasy football commissioner at the courthouse, but he is an incredibly talented person, professional, who put all this infrastructure in place and has now got us here up and running as always. So thank you, Jeremy, as well. Now, Edith has tasked me with some announcements, and before I introduce Miss Stone, I would like to just tell you all a couple of things. First, we'll have a 10-minute break after the first session. For Jennifer's first session, she asked that we hold off on questions until the end because of the way her presentation is full of information. And so if you have questions in the room here, raise your hand. I'll give you the mic. You can ask your question. And for online, you'll send a question through the chat, and then we'll convey that question to the speaker. Now, for the panel, we urge you to ask your questions as they come up. Okay, we want it to be an interactive session. And so please feel free to ask your questions at any time. At the end of the CLE, for in-person attendees, you must place your certificates of attendance that you should have in your packets on the Access to Justice Dropbox. Is that, they scan it in and send an email to you, or do they have it here? Okay. Fill it out, Dropbox is here. Online attendees, you'll receive an email later this evening. The email will contain any additional materials distributed this afternoon, and your completed certificates must be emailed to this email address, cle@arkansasjustice.org, cle@arkansasjustice.org. You must do so by August 11th to receive credit. If you run into any issues, please contact Edith at arkansasjustice.org. CLE rules require us to get your feedback, so please complete the cards in your packet and the online feedback, and the Access to Justice finds it very helpful and beneficial if you would provide your meaningful feedback, so please do so. Last, and maybe most importantly, our CLE also includes a networking reception at the end, so please stick around afterwards and mix and mingle with us. And also, more importantly, we have our partners out in the hall with tables set up. And if you please check in with them and see what maybe possible opportunities you have to volunteer with these organizations, that would be very, very appreciated and important. All right, now without any further ado, I'm going to introduce our first speaker, Miss Jennifer Thornton Stone. She is a graduate of the University of Arkansas at Fayetteville with a BA in political science, and she received her law degree from the Bowen School of Law. She's practiced law for 28 years in El Dorado, which is her hometown. In 27 of those years, Jennifer has been with the Center for Arkansas Legal Services doing family law. Jennifer enjoys spending quality time with her husband and daughter. Apparently your daughter is the highlight of your lives, or the most important part of your lives. She'll be starting her senior year in high school in a few weeks. They're band parents. What does she play? She plays the flute. And so on Friday nights during football season, you'll either see Jennifer and her husband either behind the concession stands or following the band out of town for a Wildcat football game. So she's currently also a member of the board of the South Arkansas Art Center and an active member of First United Methodist Church in El Dorado. Without any further ado, we thank you for coming today, and please give Jennifer a round of applause.
Thank you. Thank you for having me and for coming to listen about orders of protection. And there is a lot of information that I want to share orders of protection. And so we will just jump right in and get to it. And I will be around afterwards for any questions that you might have. So there are 3 types of court-ordered protections involving domestic violence. There's a restraining order and an order of protection, and also a no contact order. You'll hear individuals using these interchangeably, but they are different things. The restraining order and the order of protection are used in civil matters, while the no contact order is used for criminal matters. Restraining orders are used like in divorce cases, custody cases, to keep individuals from removing children from the jurisdiction of the court, from talking bad about each other in front of the children, not being able to keep them from selling property while that decision is being made by the court. And then we have the order of protection, and these are this is initiated by private individuals who file a petition because they feel like they're in immediate and present danger of domestic abuse, or if the respondent is going to be released from incarceration within 30 days, they can also file for an order of protection. If once the respondent is released, that person feels they'll be in immediate and present danger. And we'll come back to the orders of protection. The no contact order is used in criminal proceedings. During this time, the individual under the no contact order cannot possess a gun or ammunition, and violation of the no contact order is a Class A misdemeanor. So we've got the Domestic Act of 1991. Our General Assembly found that it was that it had an important government interest in protecting individuals from domestic violence and preventing further abuse. And so through being able to enact the protection order, they're able to remove an abuser from a household and also order other injunctive relief that would keep the petitioner safe. So it authorizes state courts to be able to act proactively to stop abuse before it happens and not have to deal with it on the back end when someone has been charged with a crime. So they were hoping it would have a deterrent effect against those individuals. Who can file for an order of protection? Anyone who's the victim of domestic abuse, a parent of a child who has been the victim of domestic abuse, a guardian on behalf of a ward, whether a child or an adult who's been the victim of domestic abuse, or an employee or volunteer of a protective of a shelter, domestic violence shelter, or a program on behalf of a minor who has been the victim of domestic abuse. So these are the people that can file. And so how does the statute define domestic abuse? Physical harm, bodily injury, assault, or the infliction of fear of imminent physical harm, bodily injury, or assault between family or household members, or any sexual conduct between family or household members, whether minors or adults, that constitutes a crime under the state's criminal statutes. So let's talk about family or household members. This includes a lot of different relationships and individuals. So it can be a married couple, so it can be spouses. It can be former spouses. It can be parents and children, persons related by blood within the fourth degree of consanguinity. So this would mean great-great-grandparents, great-great-grandchildren, first cousins once removed, any children residing in the household where there's domestic violence, persons who have presently or in the past have resided together, persons who have a child in common, and people that are in dating relationships. And dating relationships are pretty clear. It's not, it's an intimate, romantic type relationship. It's not just a casual, social, or business type relationship. And then there's the word imminent, the fear of imminent physical harm. And I've cited a case, Simmons. And in that case, the boyfriend sent girlfriend threatening text messages. And she filed for an order of protection 4 months later. So it wasn't when the incident occurred, she waited 4 months to file. The order of protection was granted by the trial court. The boyfriend appealed. He argued that 4 months later, she didn't have fear of imminent harm. The Court of Appeals held that fear had to have occurred at the time of the alleged abuse, not at the time of filing. So that's what imminent means, at the time that the alleged abuse occurred, not at the time that she filed. And so I'm going to just quickly hit the highlights of some cases that help us to understand what domestic abuse is. Newton versus Tidd, the court found that verbally controlling was not domestic abuse. So just because somebody tried to verbally control another person, that did not rise to the level of domestic abuse. Pablo versus Crowder, The court found that respondent grabbed her, screamed obscenities in her face, and burst a beer bottle behind her at a party, causing her to fear for her safety. The Court of Appeals found that upheld the trial court and said this was domestic abuse. Claver versus Wilbur. A mom filed on behalf of her 16-year-old daughter against daughter's boyfriend. Mom did not like boyfriend, and she forbid them to have any contact, and he did anyway, and they continued their relationship. The court found that this was not domestic abuse. Oates versus Oates. The husband admitted at the trial court level that they argued. He pulled a phone out of the wall and he closed the living room blinds. The Court of Appeals upheld the trial court and said that this was not domestic abuse. Davenport versus Burnley. The husband and wife had an ongoing domestic dispute, and during this time, the husband heard gunshots on the front porch of the home. He went inside, locked the door, called the police, and refused to open his door until the police arrived. The order of protection was granted to the husband. The wife appealed, saying that he didn't testify, that he was scared of her. The court held that there had been domestic abuse. So just because he didn't testify that he was scared, and that's a question I'll always ask my clients, are you scared of him? And I will use she for the victim and he for the respondent, because most of my cases that is the case, but not always. I have represented men in filing for orders of protection that have been very warranted. Bohannon versus Robinson. The mom drove under the influence with children in the car. The Supreme Court held that this was not domestic abuse warranting an order of protection. Poland versus Poland. The husband hit the wife's legs, causing bruising, and she testified that he always had a gun near him and he had pointed the gun at her. And he also threatened the daughter. The wife's order of protection was upheld at the appellate level. Smith versus Murphy. Dad struck their 4-year-old child with a leather belt up and down his body, leaving bruises. The child's therapist testified about how traumatic the experience was for the child, causing him, this is a 4-year-old child, to want to harm himself, and he needed inpatient treatment after that. The court found that this was domestic abuse. Hankey versus Quimby. The mom filed an order of protection on behalf of herself and her child because the abuse to her, the abuse to mom, occurred in the presence of the child. The Court of Appeals found that the exposure to the abuse, although it was concerning, did not rise to the level of domestic abuse, and reversed the extension of the orders of protection to cover the child. So the mom still had the order of protection because she had been abused, but the child seeing it did not rise to that level, so the child was not included. And so, and there are also, you can go back into the custody case and the visitation case and address those issues. So they had other avenues for that. Pascal versus Pascal. Ex-husband's constant phone calls, harassing emails were not enough to meet the definition of domestic abuse. The fact that he said, or else, was not enough to meet the definition of threat of physical or bodily harm. Okay. And then Stale versus Smith. The dad filed an order of protection against the child's mother. He alleged that mother's boyfriend had sexually abused the child. the order of protection was not granted because there was no evidence that mom had committed domestic abuse. Okay, and again, there's other avenues, criminal avenues to address that issue, but mom had not committed domestic abuse. And that was upheld by the Court of Appeals. What is filed? Okay, if you will go, the Arkansas Judiciary's website, arcourts.gov, and under the form section, they will have an example, a sample of a petition for order of protection. It's very good. It meets all the statutory requirements. It's pretty user-friendly. It's just got little lines you fill in, and I've handed out a copy for everyone here to look at, and boxes that you check. The important thing to remember, it must be notarized. Your client's signature must be notarized. And I tell my clients that the more details they can put on this petition, the better. And I think it also asks for like the two most recent events that have happened. I tell my clients to put everything on there, because if, usually it is not just one or two incidents that happen. By the time they get to filing for an order of protection, we've had a long history and a pattern of abuse. And if the court is not able to see that, the court will not understand what your client has been dealing with and why it is so important that they get an order of protection. Where is the petition filed? You file in the circuit court in the county where the petitioner resides. So let's say petitioner resides in Union County, but they go to Columbia County to a shelter. Once they get to Columbia County, that's where they reside, in that shelter. So they would file in Columbia County. Also, you could file where the abuse occurred or where the respondent may be served, any of those places. There is no initial filing fees. There are no service costs. If your client needs to subpoena a witness, there are no costs for that. And if the petitioner is not represented by counsel, the circuit clerk is supposed to provide them the form, help them fill it out. And then some counties have victim assistance, victim witness coordinators. And in the counties that I primarily practice in, they have these, and it's wonderful because they do all the legwork. They make sure that the respondent is served, and I just talk to the client and then show up report. So it's pretty easy. And then some counties have attorneys that handle all of the orders of protection for that county. And that's pretty good too. So that they have an attorney, because the victim witness coordinator is not an attorney. They are an advocate for that person. They help them fill out the form. They go to court with them. They sit with them, make sure they get out of the courthouse safely, get into the courthouse safely. So, so the victim witness coordinators are very important. What needs to be in the petition? So if this is the statute that sets out what needs to be in the petition. We've got to have allegations of domestic abuse, of course. The court's going to want to know, has there been any pending litigation between the parties? Because if there has, a lot of times the order of protection petition will get moved to the court that's already hearing the divorce, custody, visitation issues. The court's going to want to know, are there any order of protection filings in the past? I've had some clients that have filed many times, either dismissing them, sometimes getting an order of protection. But the court is going to want to know about that. And then, of course, it has to be accompanied by that affidavit that the client handwrites the facts and circumstances of the domestic abuse and the relief site. So the more details the petitioner can give on that, the better. The relief site is always, I want him to stay away from me and my children and family. So that's pretty simple there. So the petition gets to the court, and either the judge will sign an ex parte order of protection or will not. If the court denies the individual from proceeding with the order of protection, the petitioner can opt to have a full hearing on the merits on that issue. But if it is approved, a hearing is scheduled. Now, a hearing has to be set no later than 30 days from the filing of the petition or at the court's next court date, let's say in that county, whichever is later. The court can schedule it before the 30 days, not precluded from doing that. So respondent gets served with notice. The respondent will get the petition, the ex parte order, and the notice of hearing. And it has to be served at least 5 days before the hearing. In the case of Wills versus Lacefield, the respondent appealed because he was served 7 days prior to the hearing. Well, this individual, I guess, was representing himself and didn't know, but under the orders of protection are considered special proceedings. And so if there's a rule in there about service, let's say, which there is, 5 days before the date of the hearing, that rule will trump the rules of civil procedure. So the Arkansas Supreme Court found that the proceedings were special proceedings, and therefore the rule regarding service that is provided in the Domestic Violence Act, Domestic Abuse Act, and not the conflicting rule of civil procedure applied. Okay, petitioner's burden of proof. So you get to court and both parties are noticed. Sometimes the respondent doesn't show up, and that's a good day. And then sometimes the respondent does show. The petitioner must show by preponderance of the evidence that the domestic abuse did occur. So is it more probable than not that the abuse occurred? Standard of review on appeal. So the standard of review at the appellate level, where the trial court's findings clearly erroneous in light of the evidence presented, although there's evidence to support it based on the totality of the whole hearing, has a mistake definitely been made. The first case I cited is Walter versus Chisholm. This is a boyfriend and a girlfriend. They've had an on and off relationship for about 6 years. The boyfriend invites girlfriend over to dinner. An argument ensued over who made the potato salad. You cannot make these things up, people. So she said another woman made that potato salad. She knew he didn't do it, and she was ticked off. And so the boyfriend at that point told her to leave, and she refused. So she testified, this was her testimony. She testified that he grabbed her hair, dragged her down the hallway to his room, hit the side of her head with his closed fist, and continued to assault her for 20 minutes, kicking her in the stomach, hitting her in the face, and choking her until she blacked out. After she called the police when she left, and then she did not seek medical attention. The officer came and took pictures of her. She did have a swollen area on her face, and she had some scratches on her neck. She told the officer that he hit her in the face and stomach. She did not mention the choking, the pulling of her hair and dragging her by her hair down throughout the home. The officer testified that he did observe the swelling to the left side of her face and some red marks on her neck. He did not see any bruising on her stomach. And also at that hearing, she alleged past abuse and submitted some photographs of past injuries. So then it was boyfriend's turn to get up and talk about what happened. He said he had to, the case said, lift her up. So I'm assuming he picked her up and removed her from his home and The girlfriend, he put her outside the door and shut and locked the door. She continued to scream outside of the home, and she said she would call the police. So eventually she left, and she texted him that she was going to take away his livelihood. She and thanked him for another black eye. Boyfriend denied ever striking or hitting her. He said that she did not have any marks on her when she left. His daughter, who was also present during this whole incident, corroborated his version and added that girlfriend tried to hit her dad. The trial court did not enter an order of protection on behalf of petitioner. The Court of Appeals found that it was significant that she alleged numerous acts of abuse, but she failed to mention a majority of them to the officer. There was no question with the trial court or the appellate court that something happened, an altercation of some kind happened in that home. The court was unable to determine whether the injuries to the petitioner occurred because of her story or because the struggle, him trying to get her out of his home. The Court of Appeals agreed that the trial court, the petitioner did not meet her burden of proof as to the allegations made against the respondent. So let's see. Let's go down to Brown versus McCauley. I've had to scratch some of these because I need to make sure I get through all the material. I've got too much. So Brown versus McCauley, this involved two college students. They had an on and off again dating relationship. She alleged that he raped her. And she was awarded a 10-year order of protection. He testified at the hearing that the sex was consensual. So after the incident, she went and she told family and friends about it. She told the counselor what happened. She reported it to the police. She moved her residence 2 times so that he couldn't find her. She blocked him from calling and from all of her social media. She did not associate with their mutual friends that they had. So then she filed for the order of protection because she was afraid of what he would do once he found out that she had told people. The trial court believed petitioner's account of what happened, and the 10-year order of protection was upheld by the appellate court. The next one is Steffi versus Steffi. The wife filed because the husband threatened to hit her in the head with a fire log. He told her that a husband has every right to apply corporal punishment to his wife as he sees fit. He hit her. He picked up a hammer, threatened to bash her head in. They had 5 children together. 3 of the 5 children testified against Dad. One of the children said that Dad said anyone tried to take his children away from him, he would, quote, take them out. The only way anyone would get his kids was over his dead body. The 17-year-old testified that Dad threatened to have Mom hauled to jail and that he would pound her head into the ground. She told the court she didn't feel safe at home. So the second child testified about physical violence. The third child testified that she saw Dad pick up a board and threatened to put it through Mom's throat, and that Dad threatened to hit one of the children with a metal hanger. He told that child that he would have smashed her face in if she had been a boy or killed her by now. The trial judge awarded 1-year order of protection, which I kind of raised an eyebrow to that, but it could be that the petitioner just asked for a year. On appeal, the husband argued there was not sufficient evidence to support an award of an order of protection. The appellate court, of course, disagreed with the husband and upheld the order of protection. Next case is Baltz versus Baltz. A son filed an order of protection against his dad. A temporary order had been entered previously through another division that heard all of this family's domestic cases, all of the abuse cases, the divorce, everything. So the mother had filed for an extension of another 10 years on her order of protection. And the children were covered under the previous order of protection, but once the children turn 18, they're no longer covered. So the oldest child turned 18. Dad texted, just blew up his phone every day, texting, emailing. It says Dad left 20 voicemails in a 2-week period. When he testified at the hearing about needing the order of protection, his mother testified on his behalf as to the lengthy domestic violence and abuse that they suffered at the hands of the dad. The son testified he wanted no contact and that he continues to have anxiety and sleeping problems due to the past abuse. The dad testified he just wanted to start the healing process. So the trial court said that this situation was brought on by years of behavior. And the only reason that the 18-year-old wasn't covered anymore under the order of protection is because he turned 18. So the court gave him a 5-year order of protection. Now, the dad relied on Pascal versus Pascal, which I had mentioned a minute ago, that held constant phone calls and harassing emails did not meet the definition of domestic abuse. But the Court of Appeals agreed with the trial court and held that this situation must be viewed in context of the history and the pattern of abuse. Because of his past abusive behavior, his harassing communication could reasonably inflict fear of imminent physical harm on the son. So what relief can a petitioner get with an order of protection? There's the statutes. Thank you. The first thing is to exclude the respondent from a residence, from a place of employment, from a business, or other place where the petitioner frequents, a school, any other location. A trial court may award custody and/or visitation through the order of protection case. Trial court may award child support and/or alimony. Also, the trial court could award attorney's fees. Trial court could allow, even with an order of protection, contact between the parties with specific conditions. For instance, if the respondent gets visitation rights with the children, let's say there's a medical emergency when respondent has the child, he may be allowed to text petitioner and say, there's emergency, meet me at the hospital. So there's times where that is needed and the court can do that. Award custody of a pet. You cannot leave Fifi in the hands of an abuser. That is not going to be good. That is not going to be good. Also, the trial court can order law enforcement to assist petitioner in either having the respondent removed from the home or assist her in going to the home and getting some of her personal belongings. Also, with an order of protection, the respondent is not able to have a firearm or ammunition. So that's important. And we'll see in some cases that has become an issue. And then the court can award any other necessary relief. And this involves coercive control and disturbing the peace. So coercive control, an abuser's whole deal is control. They want to control another person. And one of the main things they do, they will isolate the victim from their friends, family, any form of support that they have. They will deprive them of basic necessities like food, sleep, medical care, They will monitor a person's movements or communications. They will look through that cell phone on a daily basis. They will know every move that the victim makes. I had a client one time tell me that she could not use the restroom or take a shower with the bathroom door closed because he micromanaged every move she made. Also, economic abuse. Most of my clients come to me and I ask them, how much does your husband make at his job? They have no clue. Does he have a 401k through his employment? They have no clue because the husband keeps all that from them, so they don't know what they have. Also, I've had cases where the victim did not want to come forward because she was not a legal US citizen. And he held that over her head that if she did not do what he said, that he would turn her in. Immigration status has no bearing on being able to get an order of protection. And then disturbing the peace. These are things hitting, threatening, sexually assaulting, harassing. So the court can also say no form of harassment. So these are some additional things that the court can do. How long does an order of protection last? You can ask for as little as 3 months up to 10 years, just depending on what your client wants, what your client feels like he or she needs. Can it be renewed once it expires? Yes, it may be renewed. I would advise that you try to renew it if it's needed before it expires so that you don't have any time in there that the client is not covered by that protection. You do have to ask for it. You have to petition the court. You have to have a hearing. And if the court finds that the threat of domestic abuse still exists, then the order of protection will be renewed. Bentley versus Bentley. Husband and wife are getting a divorce after 30 years of marriage. The wife was awarded a 1-year order of protection. Before it expired, she asked for 4 more additional years. She alleged at the hearing that since the order of protection, the original order of protection had been entered, he had violated it. He had gone to jail for the violation. She said, and that because of his methamphetamine use, he was very irrational and she feared for her life. She also testified that he had several rounds of inpatient drug treatment that were unsuccessful. And so based on the current use of meth and the fact that he did not complete treatment successfully, the Court of Appeals upheld the 4-year extension because the threat of domestic abuse still existed. Can an order of protection be modified? Yes. A modification can be made by either party petitioning the court, and you have to notice all parties and then again have a hearing, and the judge will determine whether it is warranted. The case Callaway versus Crotty, the order of protection, again, you have to prove that it was warranted to modify it. So Ms. Crotty filed for an order of protection against Mr. Callaway. They had a past dating relationship, and he was ordered to stay away from her, her kids, and her family. The trial court, and I'm quoting here from the trial court, that Mr. Callaway had consistently and persistently acted in such a way as to willfully torment this petitioner by intimidation, by threat, by stalking, and it involved her children. So Ms. Crotty had just asked for a 6-month order of protection, but this judge gave her a 3-year order of protection. Well, Mr. Callaway, he did not appeal the order of protection. He waited and he filed a modification. Basically, he didn't like the 3 years. He thought it should be more like 6 months. And he needed his gun for hunting season. And so he just wanted it changed because he needed to go hunting. Well, the court said that He attempted to relitigate the original order of protection, which the court did not let him do. She testified at that hearing that she still feared him. He continued, even though he was not supposed to have a firearm, he had a firearm and she knew it. And he had a history of extreme violence. He had a bad temper and he has a reputation that he seeks revenge. The trial court found that there had not been a change of circumstances warranting a modification. So what about when the court decides custody and visitation within an order of protection case? Of course, when you add the layer of domestic violence on top of just a regular custody or visitation case, there's factors that need to be considered that you wouldn't normally have. So of course, the safety and the well-being of the child and the parent need to be considered. The court will look at respondents' history and pattern of abuse. Now, if a parent relocates to get away from an abuser, the court will not hold that against her. And also, there is a rebuttable presumption that it is not in the best interest of a child to be placed in the custody of an abusive parent in cases where a finding by proponents of the evidence that a pattern of abuse has occurred. Hollinsworth versus Newzeski found that relocation alone does not amount to change of circumstances. So in a custody case, in order to change custody, you have to prove a change of circumstances. Relocation alone is not going to get you there. And also there's a presumption that exists in favor of relocation for custodial parents with primary custody. So the custodial parent does not any longer have to prove that there is a real advantage to her moving. There's just going to be a presumption that she did so for valid reasons, not just to keep him from visiting. The case Goodson versus Bennett. So this was a divorce case. Husband and wife have a 5-year-old son together. The husband attacked the wife. He damaged her jaw and ruptured her eardrum. The child was home during the attack. The wife was awarded a 10-year order of protection, which included the son. At the hearing, the wife testified about the verbal abuse to the child. The dad called the child stupid. Something's wrong with you, and mom doesn't love you. He threw the child on a bed and held the door shut so the child could not get out. There was testimony about how dad's behavior negatively affected the child, and that's important. That's important to show that. The child would run and hide if dad was anywhere near him. The child started acting out physically against other children at school. He would tug at his ear a lot and bite his shirt due to the anxiety that he had about the abuse of dad. So dad brought a doctor with him to court who said that she would strictly supervise the visits if the court would allow him to visit his child. The trial court held that it was not in the child's interest to have visitation with dad. On appeal, the dad argued that the court abused its discretion when it solely relied on the order of protection to deny the visitation request. The Court of Appeals upheld the trial court, stating that while the order of protection weighed heavily, as it should, in the analysis, the trial court pointed out in the decree that no appeal was taken of the order of protection. We've seen that before. And no testimony was provided at the final divorce hearing that proved modification was warranted or that it was in the best interest of the child. Mutual orders of protection, not allowed unless. So basically each party has to have grounds. They have to each file and serve each other. Each party has to have committed domestic violence and they pose a risk to the other. I know early on, I remember courts just not knowing who to believe in these cases and just said, okay, both of y'all give mutual orders of protection. And so now we have this that shows what has to happen in order to do that. Violations of order of protection. What if the petitioner violates his or her own order of protection? The statute provides that law enforcement shall not arrest a petitioner for violation of the order of protection. What if the respondent is the one? So the statute provides that the first violation of an order of protection by respondent is a Class A misdemeanor with a maximum penalty up to a year in a county jail and or up to $1,000 in a fine. The second violation, if it occurs within 5 years of that original order of protection, it is a Class D felony. Class D felony. Also, the statute points out that law enforcement can make a warrantless arrest if the officer believes that the order of protection has been violated by respondent. So real life, this is what happens because my clients tell me they respondent violates the order of protection, comes to her house. He's not supposed to be there, threatens her, abuses her. They call the police. While the police are on their way, respondent runs. So police get there and say, I didn't see anything. I don't know if anything happened. So unless she's like needing medical attention and they need to call an ambulance for her, usually nothing gets done there. So the defendant can be prosecuted for the crime of violation of order of protection. And also you can file for contempt, but under prosecuting, the state should make sure they charge the defendant under that criminal statute because the order of protection is not a criminal statute. And I read a case where a mistake had been made and they prosecuted the person under the wrong statute, got thrown out. So hopefully that doesn't happen to any of y'all. Filing for contempt. So the court may issue a show cause order if you file a motion for contempt of violating that. There's a case Sutterfield versus Sutterfield. The wife filed an order of protection on behalf of herself and 3 children against the husband. After he was served, he violated the order by going to the marital home, destroying her things, the children's belongings, and causing major damage to the home. He pled guilty in district court to violating the order of protection. He was ordered a small fine, cost, and fees. He was placed on 1 year of supervised probation and given 30-day suspended sentence in county jail. After that, the wife went and filed a motion for contempt in the order of protection case for causing about $14,000 of damage to the residents. When she returned to the home after he left, she found piles of her personal property smoldering outside of the residence. The children's clothing had paint poured all over them, and they were smoldering in burn barrels. Screws were inserted in door frames in the home. Boards were screwed to the floor. All the windows were scratched. The furniture was destroyed. The top of the washing machine was smashed in. The dryer had paint thrown inside of it, and all the cords to all the appliances had been cut. So he appeared pro se at that contempt hearing, and he denied he had done any of those things. He did not do that. The trial court dismissed her motion for contempt with prejudice because the relief sought is not an available remedy under the order of protection statute. And the evidence did not prove by preponderance of the evidence that respondent damaged the property in question. So although he pled guilty to violating the order of protection, that was not enough for this judge to establish that he, in fact, was the one that did all that damage. Well, the Court of Appeals agreed with the wife that the trial court erred in not holding respondent in contempt for violating the order of protection. Willful disobedience of a valid order is contemptuous behavior. The trial court's finding was clearly against the preponderance of the evidence. The case was reversed and remanded, and I'm happy to say she got her $14,000 in the divorce case. So, all right. So I wanted to just share with you a little bit about my experience in representing victims of domestic violence. When I'm in court, I will make sure I do not allow the respondent to have eye contact with my client, because he is going to be trying to do that to intimidate and put fear in her. And so I will position myself. I will move a podium if I need to. I will, I've had to do a little dance in front of to block him from looking at her and from her seeing him. It's also important that representing these individuals, that you understand the dynamics of the power and control in abusive relationships. Know that domestic violence, it happens across every socioeconomic, every race, every ethnic group. No one is immune from the possibility of domestic abuse. And one frustrating thing that I know, it frustrates me, it frustrates everyone, they return to their abuser, and it happens multiple times, sometimes before they decide that they want to leave for good, and they can leave for good. So why do they go back? Well, you have to understand they've been in an intimate relationship together. And then, we have what's called the honeymoon phase. He promises he's never going to do it again. And he acts so good, and it will last for a little bit. But like I tell my clients, he's not going to be able to do it for very long. And, and they fall in love again with the person that they originally married or originally got with. And so, and she may be financially dependent on him if she's got children with him. She may not have any job skills. She may never have held a job because he's probably kept her at home under his thumb, taking care of children. And so, and then also she fears retaliation. I mean, this is the most dangerous time for her when they tell someone else, they go for help. And the most popular one is, you will never see the children again if you do this. And also that legal aid lawyer, they're not real lawyers. So, yeah, my clients get told that, are you a real lawyer? Because my husband said that you weren't. Yes, I promise. I attended law school and passed the bar. So, when they do change their mind, and I tell them, I don't judge them, because I know they fear that, but I tell them I'm here. And if it doesn't work out, call me back. I'm here for you. We can continue. We can file for another order of protection. My concern is your safety and the safety of your family. That's what my concern is. Also know that the client will not trust you at first. You are a stranger to them, and they're having to tell you the most intimate, personal, and embarrassing things of their life. And so they may withhold crucial information. I ask my clients all the time, did he abuse you? And they'll go, no. And I said, I'm looking through the information I have on the client. I said, so he didn't hit you, and he didn't, do this and threaten to kill you and have a gun? Oh yeah, he did that. Well, a lot of times victims of domestic violence don't understand that that's violence because they've grown up in it, and it's just a cycle, and it just keeps going until someone stops it. So you need to tell them what you mean by abuse, because they're going to minimize it, and they're going to blame themselves a lot of times. And so I would encourage you to have patience with these individuals. And I have to remind myself that all the time. People that are traumatized, they have difficulty processing information sometimes. And so you might tell them something, and then you might write it down and give it to them, and then they'll call you the next day and ask you those same questions. And so I have to, remind myself that this is just the way it is, and just to be as patient as I can. Then others are going to come across very hostile and difficult. You're going to have clients that you don't like. And then there's going to be some that come in and they just have a real flat effect, and they don't show much emotion at all. So there's just a real variety of what your clients may come across to you as. So just know that. And then the most important thing I want to say to everyone is to listen to your clients. Listen to them. When my first year at legal services, I got a call from our then municipal judge. And he said, I need you to come across the street and talk to this lady. That's all he said. I said, all right, I'm on my way. Didn't know what was going on, but I got over there and I said, the judge asked me to come talk to you. I said, what's going on? And she said, I am not going to testify against my husband and I'm not going to do it. He can't make me do it. He can't make me get up there. And so I thought, oh, he wants me to tell her to cooperate. So I said, well, if you will cooperate, they can put him in jail and they can keep him from you. And she said, you don't understand because you've never been abused. I stopped and I said, you're right. I never have. And she said, because at the end of the day, you go home and you're safe. She said, when I go home, he's going to kill me and he'll get out of jail. You can't keep him in there long enough. He's going to kill me. From that day forward, I decided that I was going to listen to my clients. And I just encourage you to do that also, because if they say they don't want to proceed with the ex parte into making it a final order of protection, trust them. They know the abuser. They know what they have to go home to. Just provide them their options. Tell them this is what you could do. This is what you can do. But listen to them because they know what they've got to go home to. So I think I got through everything. And so I'll take questions if there are any. I know that was a lot of information very quickly, but I tried to give you the PowerPoint with all the citations because I hate it when I'm in a CLE and they start rambling numbers and I can't write as quickly as they're talking. So.
Jennifer, thank you. Excellent presentation. Very informative. First question is, when an order of protection case merges with a divorce case, does the order of protection end?
No, when and that happens all the time because they want to have the same judge that hears the divorce case. They want that same judge to hear the domestic violence case because that's going to affect the custody and visitation, other things that need to be decided in the divorce case. So no, it does not go away. Once that order is entered, it's there. It's just within the divorce case.
Any questions from the room?
Also, you need to make sure that all your clients keep a copy of their order of protection on them. Is that it? That's all? Okay. That's all. I have to sit down now.
I have one question for you.
Okay.
So Jennifer, as you know, we're here under the auspices of the Power Act, and we're looking for pro bono opportunities for lawyers. Can you speak to that?
Absolutely. The Center for Arkansas Legal Services would love for anyone to sign up to help us with these orders of protection. Like I said, there's some counties that have an attorney that represents the victims, but I would guess that probably most do not. And so them walking into a courtroom with a real attorney would be wonderful. It would be wonderful. It would empower them and make them feel safer because, like I said, this is the most dangerous time for them. It's when they tell someone else. And so they're scared to death.
We have one, I'm sorry, we have one more question. So
Okay.
if both parties live in the home and the wife wants to serve an order of protection, and the order of protection be served in the home and then he may leave?
Absolutely. And that's what happens. So when she gets the order of protection, the police will get a copy. They will go over there, remove him from the home. And then when it's safe for her to go, someone will let her know that it's safe for her to go back to the home. That's absolutely why we have the order of protection. Judge Johnson, hey, yes. Mm-hmm. Continuances. Right. It's frustrating. Well, sometimes they can help find the respondent. Sometimes sometimes they're like, I have no idea where he is and I'm glad he's gone. And as long as no further abuse is happening, no threats are happening, you can dismiss it without prejudice. And then I tell her, if he shows back up, you call me, you call victim assistance and let us know and we'll go get him. And so that's all you can do, because if he's hiding, he's hiding. I'm telling you, there's a guy down in Dallas that we've been trying to find, and the police down there have just really have gone above and beyond to try to get this guy, and we still don't have him. And so I think it's been continued for another couple of months to try to let them, maybe he thinks it's gone away now, and so maybe they can get him, but his family's covering for him and everything. So that happens all the time. Yeah. Yes. Yes. Mhm. Mhm.
The respondent, some of these respondents don't care.
They don't.
And
To
they
them,
don't
it's
get
just
in
a piece of
jail.
paper. They don't care. But until the judges start, and this is what happened where in the state where you lived, because I think I'm not having that outcome here in Arkansas, but until the judges will start doing something, it doesn't give the order of protection any teeth. It doesn't give it any, you've got to be able to have your judges back it up. So
Are they going to jail? Are respondents going to jail in Arkansas for violating orders of protection?
I believe they are, when you can prove it. Now, the situation where my client calls the police and the police come, by the time the police get there, he's gone. If there's like not a need for an ambulance, nothing happens. And so, and I don't know what to do about that. I don't know. But I always encourage my clients to tell the police you want to make a report. Always make a report. You need somebody to document your client's statements. So.
We are out of time. Thank you so much. Our next panel discussion begins at 2:50. So y'all are on a break. Thank you.
Yeah, we're gonna turn the projector off.
I mean, do y'all want to hear?
Joe, you got it.